So yeah, just 10 minutes per contestant, and extra 15 seconds if your time elapses. And I'll be holding up the 3 minute remaining and 1 minute remaining, okay? So we can't, for now, I can't see. Can you see the names on the spreadsheet?
Let me double check.
Yeah, but I trust you guys know who is the appellant and who is the respondent for this case, right? So appellant 1, you can begin, and I will start the timing.
Good morning, justices, and may it please the court. My name is Nicholas Gill, and I, along with my co-counsel, Emily Soa, appear on behalf of Her Majesty the Queen in the case at bar. The question before the court today is a constitutional one. And that question is whether the definition of Aboriginal peoples of Canada is meant to include the Lakes tribe of the Colville Confederated Tribes of Washington State, therefore granting and affording the rights under Section 35, subsection 1 of the Constitution Act 1982 to Mr. Desautel, the respondent in the case at bar. The constitutional question in the case at bar raises two substantial issues before the court. The first one is whether under the definition of provided by Section 35, subsection 1 of the Constitution Act, we are to include foreign Aboriginal societies to the country of Canada. The second substantial issue in the case at bar is whether the relevant provincial legislation, that being Sections 11.1 and 47A of the Wildlife Act, are of no force or effect when it comes to Mr. Desautel's rights and the claims that he puts before the court today. I will be addressing the first issue before the court, that is all matters related to Section 35, subsection 1 of the Constitution Act 1982, while my co-counsel will be addressing all issues regarding the relevant provincial legislation, as well as any other further public policy considerations. Based on the aforementioned, we ask the court today to allow the appeal and overturn the decision of the Supreme Court of Canada, as well as to submit a verdict of guilty on both counts of hunting without a license, according to Section 11, subsection 1 of the Provincial Wildlife Act, as well as hunting big game while not being a resident of this country, in accordance with Section 47A of the Wildlife Act. When it comes to the definition of Aboriginal peoples of Canada under Section 35, subsection 1 of the Constitution Act 1982, we urge the court to engage in a purposive interpretation of the legislation in place that takes into account the linguistic, the philosophical, and the historical context of the legislation in place. When it comes to the purposive interpretation of Section 35, subsection 1, we urge the court to determine today that to overshoot its purpose in order to include the Aboriginal societies of Washington State, the Lakes tribe of Colville Confederated Tribes, it's to undermine the intention of the framers of the Constitution when drafting the Constitution Act 1982. And that is supported by all the linguistic, historical, and philosophical context of Section 35, subsection 1 of the Constitution Act.
Counsel, I'll stop you right there. Is the historical framework really relevant anymore? I mean, we have cases like Edwards that famously proclaim the Constitution is a living tree. The Charter is meant to continue growing. We don't necessarily have to rely on the historical basis for why a certain provision was enacted, because we have a modern society that continues to evolve with our modern laws. So are you saying we should only rely on this historical context? Pardon me.
Respectfully, Your Honor, the appellant submits today that the purpose of the interpretation of the legislation in place, it's not to only look at the historical context in the case at bar, but to adopt a holistic approach that takes into consideration all the contexts relevant to the legislation, as well as the overarching purpose of the same.
So counsel, what's the overarching context? Are you telling me we look at it from a 1982 perspective?
Well, the overarching purpose of the legislation in place, Justice, it's to protect and guarantee rights to the Aboriginal peoples of Canada as a linguistic context.
When? Aboriginal rights when? Tell me how, what's your time frame? When does somebody become an Aboriginal group?
The Aboriginal group makes reference to the Aboriginal societies that were in Canada prior to contact, as well as the reconciliation with their prior existence and contemporary existence and the sovereignty of the Crown.
So you just said, sorry, Counsel, you just said prior to contact. So if we look at it prior to contact, aren't you just arguing for the respondent?
Respectfully, Justice, we wouldn't submit that we're arguing for the respondent when we say prior to contact. We do recognize the fact that Aboriginal societies lived in Canada prior to European settlers coming to the country. The Constitution Act 1982 seeks to reconcile the existence of these societies and the sovereignty of the Crown so far as they are still within the boundaries of Canada. When it comes to the context of the case at bar, we can see the fact that the framers meant to include Aboriginal societies within Canada and not outside the boundaries of the country, regardless of the temporal element in place.
If you're proposing a purposive interpretation, and you've just told us that the purpose of Section 35 is reconciliation, and we have this notion that the only reason this tribe is no longer in Canada is because of colonialism, because Canada essentially forced them out, why are we not integrating them within this purposive reconciliation-based interpretation?
Justice, because to incorporate the Lakes tribe of the Colville Confederated tribes of Washington State would be to grant Aboriginal rights to societies that are no longer part of the Canadian society.
But it's Canada's fault they're not part of the society. Are we to ignore the notion that Canada simply removed these groups?
Well, if we base ourselves in the evidentiary record and the trial judge's decision, we can see the fact that the trial judge made it clear that although the move was not voluntary, and I quote, nobody pointed a gun at the Aboriginal societies that moved away from Canada. When we take a look at statements like these, and then we take it into account along with the purpose and context of the legislation in place, therefore adopting a holistic approach to the facts, then we urge the court to determine that the Aboriginal societies outside of this country are not meant to be included within the definition of Aboriginal peoples of Canada.
Counsel, nobody pointed a gun. Can you expand what you mean by that, please?
Certainly, Justice. What the appellant means by that is simply to refer back to what the trial judge's determination in the case at bar in the trial court of British Columbia, where the trial judge stated that nobody pointed a gun at the Aboriginal societies that left the country. And although we recognize the fact that the trial judge also said the move was not voluntary, it wasn't specifically determined that Canada drove these societies away from the country.
Cal, I don't want to get hung up on this terminology. Can you point me to a paragraph where the word gun was used?
Justice, I believe the specific phrase was used in the beginning paragraphs of the dissent.
I'm finding it in paragraph 5 of the majority. I'm not quite sure how the dissent factors into your appeal. The trial judge did not find that the cynics were forced out of Canada at gunpoint. Fine. Nor did she find that the move was voluntary. Okay, so can you tell me what the difference is here? How do I reconcile that? It's not voluntary, but it wasn't at gunpoint. Is there some sort of middle ground standard that I'm not seeing here?
Well, the determination that was made in the trial court was that the move of the Cynics people into the Lakes tribe and the Southwest territory of their traditional lands was due to a constellation of external factors rather than a single cause originated by Canada's conduct.
Okay, fine. Counsel, fine. But doesn't that go to the second part of this analysis? You're arguing that this section is unconstitutional. If we want to argue the particular circumstances of these peoples, we can do that. I would certainly argue we should defer to the trial judge, but putting that aside, you haven't convinced me why this legislation itself is unconstitutional. And I don't mean to ramble, but let's turn back to this whole discussion about point of contact. You said in your argument that we need to look at it from the initial point of contact, and you seem to be arguing before this court that we shouldn't do that. We should be looking at it at the point the charter was written. So which one is it?
Justice, the appellants, I see my time is coming to an end. May I have a time to answer your question and briefly conclude?
That's up to the Chief Justice, Counsel.
Yes, you may. You may have 15 seconds.
Thank you, Chief Justice. When it comes to the overarching context of the Constitution in place, we take a look not only at the point where the Constitution was written, but also before, as it gives us a purposive interpretation and context as to what the legislation in place is meant to apply to and who is meant to include. But based on this determination we asked the court to make today, we then move to determine whether or not there is a principle of continuity in the actions of Mr. Desautel when coming
Counsel,
to
your time has elapsed.
Thank you, Justices.
Good morning, Justices. My name is Emily Soa, and I will be continuing the submissions begun by my co-counsel, Nicholas Gill. My submissions today will be threefold. First, being that there are implausible and problematic results in regards to public policy if the lower court's decision is upheld. Second, that Mr. Desautel does not satisfy the Vanderpeet test in its entirety, and therefore must not be awarded the rights of Canadian Aboriginal peoples under Section 35(1) of the Constitution Act of 1982. And third, that there is a lack of continuity in practice involved in the case at bar, and is inadequate to serve as an indicator of validity for Mr. Desautel's actions. Justices, it is in the best interest of the court to overturn the decisions of the lower court today. To begin, we submit that Section 35(1) did not constitutionalize the rights of Aboriginal groups residing outside of Canadian borders. If these rights are upheld under Section 35(1), then the Crown must uphold a plethora of rights for non-Canadian citizens, setting a precedent for these non-citizens to obtain the rights of a Canadian without stepping foot within our borders. Upholding the judgment of the lower courts would simply overturn the principles of democracy as known today, and one must acknowledge that upholding the interests of rights holders outside of Canada may conflict with those within our borders, being said Aboriginal peoples. The principle that geographic location and citizenship cannot impact democratic participation is a direct contradiction to Canada's patriation and our democratic system as a whole.
Well, are we giving, Counsel, we're not giving them the right to vote, are we? We're giving them their rights under treaties that existed prior to Confederation, and certainly prior to 1982.
Justice, under the Crown's duty to consult with Aboriginal groups, the groups in need of consultation, what my co-counsel and I are submitting, this influx of groups are being awarded the rights under Section 35(1) of the Charter to use, profit, and benefit from Canadian land would upend generally having these individuals and permitting them to be consulted in regards to issues of Canadian land and Canadian treaties that may not specifically directly involve their group in particular. Allowing Mr. Desautel to hunt on this land would set precedent for other groups to be allowed to use the land awarded to Aboriginal peoples in Canada, though they are not involved in the treaty themselves, just based on land borders. It would award them rights that were not already awarded to Canadian citizens. And that is the concern that myself and my co-counsel are submitting on behalf of the appellant today.
To Canadian citizens or to Aboriginal groups? Is there not a fundamental difference?
Justice, Aboriginal groups within Canada are Canadian citizens. Mm-hmm. Therefore, allowing groups outside of Canada who do not have this citizenship or this patriation within the country, allowing these groups to have similar interest in terms of creating a tiered system of reconciliation. And by that, we submit that, the example that I submit is that Aboriginal groups within Canada and Aboriginal groups outside of Canada, there will have been and will continue to be situations in which their interests do not directly correlate. If we are to allow Mr. Desautel to engage in these practices on Canadian land today, this is setting precedent to allow groups from outside of Canada to participate in actions that may conflict with the interests of Canadian citizens, including those of Aboriginal people. And if we are trying to create reconciliation and create an environment where we can uphold and uplift Indigenous voices within Canadian borders, this will create an issue, as we do not want to create a system of tiered reconciliation in which one group may be valued higher than the other when it comes down to the end of the day. On the note of foreign interest in Canadian claims, overturning the decision of the lower courts would inhibit foreign groups from investing their interests in Canadian territory with defense of the Constitution. Allowing the Lakes Tribe to hunt on Canadian land would set precedent for all groups that may define themselves as Canadian and Aboriginal peoples ancestrally to claim the right to use constitutionally protected land for their own interests and to use it, and I quote from the trial judge's decision, the exclusive right to decide how the land is used and the right to benefit from those uses. This would infringe on the rights of Canadian sovereignty through sheer ignorance of mobility rights, therefore demeaning Canada's position as a sovereign nation in the process. The intent of the drafters of the Constitution was to protect the rights of Canadians with exceptional protections of those identified as Canadian Aboriginal peoples. In this instance, the appellant submits that this does not apply to Mr. Desautel. To be considered a Canadian Aboriginal peoples, our friends across the bar may suggest that the Vanderpreet test must be applicable. But contrary to that, as noted by my co-counsel, we submit that Mr. Desautel does not satisfy this test. To begin the test, one must pinpoint the specific act that ought to be protected. In the case at bar, it is hunting a cow elk in Sinix territory. From here, it must be determined that said practice is integral to the culture of the persons or people performing it. As submitted by the Attorney General of Alberta in paragraph 63, the appellant submits that this practice is not integral to the cultural traditions of the Sinix people due to its lack of continuity. To be a continuous practice, one ought to use the land in question to perform the cultural tradition. In the case of Mr. Desautel, this need has not been met. And finally, similarly to the dissatisfaction of part 2, this practice ought to be connected to a continuation of pre-contact practice. As the appellant has just submitted, Mr. Desautel does not satisfy this element due to the lack of continuity. Though any ambiguity is to be resolved in the favor of Aboriginal peoples, it is very clear that these peoples are not meritorious of the rights provided under section 35(1), and there is no ambiguity to be had, as we submit that they are determined to not be qualifiers of Aboriginal Canadian peoples. As touched upon in our analysis of the Vanderpreet test, the appellant submits that continuity is an essential element to the claiming of Aboriginal rights in Canada, and this continuity is not present in the case at bar. The lower court's discrepancy in the idea of continuity is one that has flawed their interpretation of the Vanderpreet test, and has attempted to afford those who do not merit Canadian constitutional Aboriginal rights the freedom to disobey laws of the general population, and this is something that must not be allowed.
Counsel, I don't know if I am convinced by this interpretation. Wouldn't this interpretation exclude Aboriginal peoples who are forced to move out of Canada, and this would risk perpetuating the historical injustice that was suffered by Aboriginal peoples at the hands of Europeans?
Justice, my co-counsel and I do not deny that there was displacement of Aboriginal groups caused by colonialism and the Canadian government. But in the context of the case at bar, this should be taken on a case-to-case basis to understand greatly the differences between one instance and the other. An example of this being demonstrated on terms of continuity is the sense that Sinix people continued to use Canadian land after treaties were established, therefore demonstrating that the colonial treaties and the land borders put in place were not the sole factor in the reason that this tradition died out in Canada.
Counsel,
yes.
Can you tell me why this court should not defer to the trial judge?
May you repeat your question, sorry?
Can you tell me why this court should not defer to the trial judge on her findings of fact on this issue?
Justice, my co-counsel and I submit that there was an error in the logic of the trial judge as discussed at the lower court by Justice Cote in his dissent. We submit that the situation at hand in discussing the cultural and historical context, as aforementioned by my co-counsel, is much more pivotal than it was brought to terms at the lower court. In the example at hand, we are submitting that the Oregon boundary treating is not the reason that there is no consistent continuity in the hunting practices and descents of the Sinix people. but it is proven that the Lakes tribe continued to hunt on British Columbia's land after the treaty took action and stopped in the 1930s. Therefore, it is reasonable to presume that the treaty is not what inhibited the Sinixt and Lake people from hunting in British Columbia. Taking into account not only physical continuity, but intellectual, historical, and philosophical history must be engaged to be considered a traditional practice, which is simply not the case as demonstrated by this fact of history. Therefore, when examining the years in which no Sinixt descendants hunted on treaty grounds, the lack of continuity cannot be rationalized by colonial and treaty restrictions, as those were long ignored.
The treaty is not the only thing that guarantees continuity. Section 35 isn't reliant upon existing or what once was treaties. That's the point of the Vanderpeet test. It's to determine when a right exists where there is no treaty, because we can't affirm things that don't exist. And so I don't understand how there's no continuity, because there is no requirement of an unbroken chain. So we have them hunting in the 30s, we have a pause, and then we have the Lakes tribe now beginning to hunt again. They are taking advantage of the right that they once had, and there's no requirement of an unbroken chain. So I pose this question to you. I know you have 1 minute left. How come, or can you explain to me why this action now taken by the Lakes tribe of them hunting is not an example of continuity, of them continuing to take advantage of their right after or since the 30s?
Justice, my co-counsel and I submit that continuity may not be the primary essential aspect in distinguishing whether something is or is not a cultural practice or a traditional practice. But taking
Counsel,
into account,
your time has elapsed.
Justices, may I have a moment to finish my answer?
Yes, you may have 15 seconds. Thank you.
Thank you. So justices, in terms of distinguishing whether or not an individual act is an act of traditional cultural significance, a demonstration here is that this practice was not engaged within in Canadian borders. Though the continuity is not the essential element, this further proves that history, culture, and philosophical elements are also not met and not essential to be done within Canadian
Counsel,
borders.
your 15 seconds has elapsed as well.
Okay, I will be beginning my timer now. Good morning, members of the court. My name is Sydney Gummerson. My co-counsel is Shania Harjai, and we are the counsel on behalf of the respondent, Mr. Richard Lee Desautel. The position of the defense is that the Supreme Court correctly ruled, and as such, we are respectfully requesting that the members of the court dismiss the appeal and uphold the decision of the Supreme Court in exempting Mr. Desautel from the Wildlife Act provisions under which he was charged. The respondent has two submissions that will be addressed today. First, I will submit that on a purposive interpretation of Section 35(1), the expression Aboriginal peoples of Canada means the modern day successors of Aboriginal groups that were located in Canadian territory at the time of European contact. And this may include Aboriginal societies that are no longer located in Canada. Therefore, Mr. Desautel's Aboriginal right to hunt in traditional Sinixt territory as a modern day successor falls under the scope of Section 35(1). Second, my co-counsel will submit that Mr. Desautel's claim satisfies the Vanderpeet test for proving an Aboriginal right under Section 35(1), including the continuity element. Due to this, subsection 11(1) and 47A of the Wildlife Act are of no force or effect when it comes to Mr. Desautel hunting on traditional territory. To begin, as the Supreme Court has often recognized, Section 35(1) must be interpreted in a purposive way. On interpretation, the respondent submits that the scope of Aboriginal peoples of Canada is clear. It must mean the modern day successors of those Aboriginal societies that occupied Canadian territory at the time of European contact, the original peoples of Canada. As a result, groups whose members are neither current residents nor currently located in Canada can be Aboriginal peoples of Canada. Mr. Desautel, as a modern day successor of the Sinixt tribe, is able to do so under this definition. An interpretation of the expression Aboriginal peoples of Canada in Section 35(1) that includes Aboriginal peoples who were here when the Europeans arrived and later moved or were first to move elsewhere reflects the purpose of reconciliation. This is and should be a primary goal of Canadian institutions who are working to build a better relationship with the current Aboriginal peoples of Canada. The two purposes of Section 35(1) are to recognize the prior occupation of Canada by organized autonomous societies and to reconcile their modern day sovereignty over them. By contrast, an interpretation of Section 35(1) that excludes Aboriginal peoples who were forced to move out of Canada would risk perpetuating the historical injustice suffered by Aboriginal peoples at the hands of Europeans. In Manitoba Métis Federation in Canada, it's noted that the Honour of the Crown recognizes the impact of the superimposition of European laws and customs on pre-existing Aboriginal societies. Aboriginal peoples were here first, and moreover, it bears emphasis that Section 35(1) did not create Aboriginal rights. Aboriginal rights were here long before 1982. And while the Honour of the Crown looks back to this historic impact, it also looks forward to reconciliation between the Crown and Aboriginal peoples in an ongoing, mutually respectful, long-term relationship, as stated in Beckman and Little Salmon, Carmacks First Nation. Aboriginal peoples in the context of legislation under Section 35(1), including Aboriginal peoples who occupy Canadian territory prior to European contact and later move, would serve this purpose of contributing to a goal of a mutually respectful long-term relationship.
I need you to actually discuss the words of Section 35. I understand we have to take a propositive interpretation, and I understand that the purpose of Section 35 is reconciliation, but we can't ignore the actual words of the statute, and statutory interpretation is essential to actually understanding what "of Canada" means. And your friends submit that "of Canada," when taken in a literal way, the simple interpretation, which is a method of statutory interpretation, means Aboriginal groups residing in Canada. And so I really need you to discuss that, or else, I mean, the propositive interpretation is not all we can look at.
Yes, Justice, the appellant submitted that an interpretation of Section 35(1) in context would mean only those who are currently residing in Canada. However, the phrase Aboriginal peoples does suggest that it applies to those who were originally here before the Europeans. Additionally, the arguments about the linguistic context of Canada that would result in those Aboriginal peoples who are currently located in outside of Canada being excluded from this protection, despite being a part of the original peoples of Canada. However, while there may be reason to interpret the phrase Aboriginal peoples of Canada in the same way across the Constitution Act 1982, this provides little assistance in the present appeal. For example, while the text of Section 35(2) defines Aboriginal peoples to include the Inuit, Indian, and Métis people of Canada, this once again does not specify a citizenship or residency requirement, despite including the words "of Canada." Justifications for the exclusion of the First Peoples of Canada were also used by the appellant by exploring the historical and philosophical context, where it was said that the intention at the time of creation was not to extend across the border. Although it's claimed that the purpose and intent was to protect Aboriginal rights, these rights did not arise because of the Constitution. They existed before.
Counsel, could it have been the intention when the charter was written to just open up the floodgates and say anybody from anywhere in the world can make this claim? Doesn't there need to be some barriers?
The perspective in the creation of Section 35(1), the respondent submits, looks backward but doesn't consider who was here first. It's important to instead look forward in order for reconciliation and a proper purposive interpretation that considers the modern day situation. While the respondent recognizes that this process may be challenging when it comes to identifying groups outside of Canada, as the court said in Powley at paragraph 49, the difficulty of identifying members of the Aboriginal community must not be exaggerated as a basis for defeating their rights under the Constitution of Canada. Using "of" does not necessarily also mean that there is a geographical qualifier. This is based, for example, in the Frank and the Queen, where Indians of the province, they determined, refer to only those residing within. However, there is no reason why Aboriginal peoples of Canada must be interpreted in the same way as Indians of the province in the National Resource Trade Agreements. This is because, as cited in Daniels in Canada, the National Resource Trade Agreements are constitutional agreements, not the Constitution, which requires a completely different interpretive exercise. As well, the respondent would like to...
Sorry, I would just piggyback off Justice Goodman's question. I don't think you really addressed the floodgate issue. Is it your submission that there is no time limit? There's no guarantee of when somebody can actually claim these rights? We are to just open up Section 35 to anybody, no matter the time frame, who has an ancestral interest in Canadian lands?
As the original peoples of Canada, such as Mr. Desautel's predecessors, those who are located outside of Canada who are attempting to claim rights under Section 35(1) are simply attempting to practice their traditional practices that were here before European contact. The respondent suggests that negotiations would be a good practice to take into account. Negotiation has the potential of producing outcomes that are better suited to the party's interests, while the range of remedies in a court is narrower. The settlement of Indigenous claims always has a political dimension, and this can be best handled through the process of negotiation.
Are you not asking this court to make a political determination, though? Is that our place?
Sorry, Justice, do you mind rephrasing that question?
Well, you're right, it is politics. And from a policy perspective, maybe we do need to do better when it comes to truth and reconciliation. Is that for this court to put its own stamp on?
As representatives of the Canadian institution, reconciliation should be a primary purpose. If this means looking at prior legislation or looking forward to creating new outlets, then yes, I do believe that this is something that the court should be doing.
Tell me why we have the right to do that? If we interpret this section as dealing as in the same way the appellant is suggesting, how does this court have any jurisdiction to overrule that? I mean, that's for Parliament, is it not?
Yes, sorry, I see that I'm about to lapse time. May I have time to answer your question and briefly conclude?
Yes, you may have 15 seconds.
Okay, thank you. As the courts, we can release precedent that may be followed by Parliament to introduce new legislation, and the respondent submits that this is something that needs to be taken forward now. My co-counsel will now submit that Mr. Desautel is able to prove the existence of his Aboriginal right to hunt in traditional territory through the Van der Peet test, including elements of continuity.
Your time has elapsed.
Before I begin my submissions, can I just ask if everyone can hear me all right and if everything is all right on my end? Thank you. I will now begin my submissions as well as my timer. Good morning, members of the court. My name is Shania Harjai, and I will be concluding the submissions on behalf of the respondent, Mr. Richard Lee Desautel. The respondent submits that Mr. Desautel's claim satisfies the Van der Peet test for proving an Aboriginal right under Section 35(1) of the Constitution Act 1982, and that it does so while also fulfilling the element of continuity. As such, Sections 11(1) and 47A of the Wildlife Act are of no force or effect with respect to hunting on traditional territory. Moving forward, my apologies, the Van der Peet test operates as a criteria used in courts to prove the existence of Aboriginal rights. The analysis of the test includes 3 parts, in which the first part works towards characterizing the right claimed in light of pleadings and evidence. The second part determines whether the claimant has proven that a relevant pre-contact practice, custom, or tradition existed and was integral to the distinctive culture of the pre-contact society. The final part is working towards determining whether the claimed modern right is demonstrably connected to and reasonably regarded as a continuation of the pre-contact practice. The continuity element is important to act as proof of an Aboriginal right and plays an active role in all parts of the Vanderpeet test. Continuity deals with the question of whether a modern practice is a continuation of a historic practice. It is different from the threshold question discussed in the previous submission by my co-counsel, which deliberated whether a modern group is a successor of a historic group and thus an Aboriginal peoples of Canada. The notion of continuity plays a role both at the second and third stages of the Vanderpeet analysis, which leads us into the second stage of the Vanderpeet analysis, showing and demonstrating that a practice is integral to the claimant's culture today and that it has continuity with pre-contact times can act as a form of proof that the practice was integral to the claimant's culture pre-contact. And it is the position.
Just on that point, can you just give me your opinion? Is the practice that's integral to their culture the ability to hunt in general, or is it the ability to hunt on these lands in British Columbia?
Yes, Justice. It is the position of the appellant that traditional territory is incredibly integral to the culture of distinctive Aboriginal societies. As the first people of Canada, the way their societies worked had a large basis in claim of Aboriginal land. Certain areas were claims of certain distinctive societies, and as such, hunting in traditional territory was completely integral to the culture of these distinctive Aboriginal societies. In the case of Mr. Desautel, the Aboriginal right claimed is a right to hunt for food for social and ceremonial purposes within the traditional territory of the Sinext in British Columbia.
Okay, so counsel, you tell me that this right exists. Madam Justice Cote was quite concerned about the burden falling on you to present evidence of continuity. Can you tell me what evidence was before the trial judge?
Yes, Justice. The respondent would like to submit and acknowledge that while there were periods of time in which no hunting took place, importantly, there was no significant dissimilarity between the pre-contact practice and the modern one. Additionally, the act of hunting in traditional territory in British Columbia was never forgotten in the minds of the Lakes tribe, and similar hunting practices continued in Washington state, which is where the Lakes tribe resides. And as the Lakes tribe...
I'll let you continue with that answer. I just want to clarify. When you say no hunting continued, do you mean no hunting continued in British Columbia or no hunting continued at all, not even south of the border?
No hunting continued in British Columbia, while hunting did continue of a similar practice in Washington state. And as the Lakes tribes are the modern day successors of the Sinext people, the modern day practice of hunting in this territory is simply a continuation of this traditional pre-contact practice. Mr. Desautel was simply exercising his traditional practices. Which brings us to the third stage of the Vanderpeet test, which is where the question...
Counsel, hold on. If Justice Goodman, as long as he doesn't have a follow-up on that question, I certainly do. We know from cases like Vanderpeet, which you're citing, that Aboriginal rights are not static. They don't stay still, they modernize. And that's why an unbroken chain is not required, for example. But if hunting continued, it just didn't continue in British Columbia, but it certainly continued south of the border. Is that not evidence of the right simply changing and modernizing to the point where it's no longer necessary to hunt on Canadian territory because the practice continued and changed so that it's now more relevant in the United States?
Yes, Justice. The respondent holds the position that the right in which the rights claimed of Aboriginal people must be allowed to evolve because, as discussed, if Aboriginal rights are not permitted to evolve and take modern forms, they will become utterly useless. And it is the position of the respondent that this includes that pre-contact practices have evolved to include modern day successors. As we can see, it was not forgotten in the minds of the Lakes tribe. The practice developed into Washington state. However, the act of hunting in British Columbia was not a right that was void or frozen for the Aboriginal peoples, for the Sinext, and eventually the Lakes tribe.
I want to go back to my evidence point, though, okay? Because Justice Cote is very clear that your evidence is just not there. And that's the record we are dealing with right now. I'm going to read it. Given that the evidence of continuity is amorphous and imprecise in many respects, there is no basis for the trial judge could have drawn an inference of continuity. So I'm interested to know if I'm going to ask you two questions. One, is the evidence there? And two, like I asked the appellant, even if we think it's not, should we be deferring to the trial judge?
Thank you, Justice. And the idea of continuity is incredibly important in this case. And while the appellant submitted that continuity requires an ongoing presence in the lands over which the Aboriginal right is asserted, as discussed by the trial judge, this simply is not the case. That while the practices are rather undocumented and there is not strict and full evidence of exactly what happened during the times of inactivity in which hunting did not take place in British Columbia, it must be understood that similar practices continued and that continuity in an unbroken chain is not required and has never been an explicit component on the test for an Aboriginal right in Vanderpeet, nor is there any basis of adding it in the future, even where the claimant may be outside of Canada. The appellant raised that there should be an unbroken chain of continuity in order to continue exercising an Aboriginal right. However, as Justice Lamer explained in Vanderpeet, an unbroken chain of continuity is not required. Additionally, Justice McLaughlin also noted in Vanderpeet that it is not unusual for the exercise of a right to lapse for a period of time. The appellant submitted that an Aboriginal right can be lost or abandoned by non-use or a period of dormancy. However, as discussed by my co-counsel, as well as touched on by myself, this would simply defeat the purpose of protection under Section 35(1), as we would not be allowed to move forward in the future of reconciliation and prioritize that in the Canadian institution. Moving forward with this idea of floodgates, it must be understood that in the position of the respondent, judgments such as the case at bar must be made on an evidentiary basis. Aspects such as in the case of Mr. Desautel, in which the Lakes tribe did not forget the acts of hunting and similar practices continued in Washington, along other cases, must also be taken into consideration. As such, the idea of a floodgates situation is not something that holds a large issue. It is not as though the respondent is submitting that we must grant overreaching rights to Aboriginal peoples of Canada. Rather, it must be understood that cases such as this will continue to operate under the Vanderpeet test. However, the test must be able to take into consideration and understand that people such as Mr. Desautel do satisfy the test at hand. And as such, due to the continuity element of the Vanderpeet test being met by the continuation of the pre-contact practice of hunting in traditional territory by a modern successor of the Senex tribe, Mr. Desautel proves that he was exercising an Aboriginal right. As such, sections 11(1) and 47A of the Wildlife Act are of no force or effect with respect to hunting on traditional territory in the case of Mr. Desautel.
Is the essence of your argument for continuity that they didn't forget the land? Do you have anything more?
Justice, I see my time has almost elapsed. Can I request another 15 seconds to answer your question and conclude?
Yes, you may.
Thank you, Justice. It is the position and the submission of the respondent that through, yes, the fact that the practices were not forgotten, similar practices continued in Washington state, and the notion set forth by judges in the past that an unbroken chain of continuity is not required, and that lapses of time are allowed and periods of dormancy do not determine anything. It is the submission of the respondent that as such, Mr. Desautel was exercising his right. Barring any further questions, the respondent therefore concludes their submissions. Thank you, Justices.